Good morning, good afternoon, or good evening, wherever you may be in the world. My name is David Horrigan. I am Discovery Counsel and Legal Education Director at Relativity. I'm an alumnus of the University of Florida Levin College of Law, and so it's my honor to be with you here for our 10th annual E-Discovery Conference. And I'm also pleased to have another alumnus of the law school, one of the truly luminary, insightful judges in the world of e-discovery law. He obviously does many more decisions than e-discovery, but he is well known in the world of e-discovery, authoring some of the most well-known opinions, as well as a really important law review in 2020 about the role of the judge in e-discovery. Of course, it is the Honorable William Matthewman. He is United States Magistrate Judge for the Southern District of Florida. The federal judge is based out of the Palm Beach Court, and he has had a long career in the law, even before he became a judge. Before ascending to the bench, he served both as a police officer and as a defense attorney, having some very well-known cases that may have ended up on a television near you. Judge Matthewman, welcome back to the alma mater, and thank you for being here with us.
Well, thank you, David. Good to be here, and always nice to be back at the University of Florida. It's a great college and a great campus.
Go Gators. Judge, we thought we would talk to you a little bit today about walking through the e-discovery life cycle. And of course, the first topic there is preserving the evidence. You've had some important cases on preservation. Of course, preservation leads to spoliation. Not that you're giving any legal advice or any tips from the bench, but generally, based on your years of experience, what would you like people coming before the courts to know?
Well, first of all, preserve. I really think that's important. When you first are involved in the case, and under the 11th Circuit case law, it says that when you have a reasonable expectation or a reasonable anticipation of litigation, you have a duty to preserve evidence, relevant evidence. So if you're a plaintiff's lawyer and Mr. Smith comes to you about a lawsuit, and if their phone or their computer or any other devices that they have might have or does have relevant evidence on those devices, you have a duty at that point, if you're going to be filing a lawsuit, even if it's 6 months before or 9 months before, whatever it might be, you have a duty to preserve that evidence. And if you don't preserve the evidence, you could run into a problem later on. So I really think it's important for lawyers, it's plaintiffs' lawyers, defense lawyers, whenever you get involved in a case, and if litigation is ongoing or if litigation is reasonably anticipated, really important to make sure that you are preserving the evidence, because you can't produce it later if you haven't preserved it. And it's probably more than just sending out a memo or something of that nature. I think you have to make sure that you contact the correct custodians, that you contact the correct individuals. You know, if it's a single plaintiff, that may be easier. If it's a company, that may be harder. And make sure that they are taking affirmative steps to preserve the evidence, because it's your duty, number one, but it's probably also going to help your client in the long run. So you want to make sure that you preserve the relevant evidence so it can be produced later on.
Thanks, Judge. You said one of the things in there that's a buzzword for those of us in e-discovery law, and that is the reasonable anticipation of litigation. Years ago, we used to hear people coming in saying, hey, well, you know, no one sued me yet. I didn't have to preserve things. Do you see that at all these days, or do people really pretty much know, hey, it's time to advise your clients, even if you suspect there may be litigation, you need to start preserving evidence?
No, I still see issues and I still see problems. And that's why I think it applies to both sides. It applies to the plaintiff's lawyer who gets a client, comes into the office and they decide they're going to sue. They may not get that lawsuit together for 3, 6, 9 months. They still, during that period of time, have a reasonable anticipation of litigation and a duty to preserve. Likewise, if a potential defendant gets a preservation letter or gets a claim letter, gets a letter saying that we're asserting a claim against you, or let us know who your insurance carrier is, at that point, I think that the defendant is probably on reasonable notice that there is pending litigation, and they would have a reasonable anticipation of litigation. So I still see it as being an issue. I think it's better than it was in the past, but it really is important that lawyers understand that their client can have a problem down the road if they don't preserve, and they themselves as attorneys could run into an issue as well down the road if they don't make sure their clients preserve.
Thanks, Judge. And all right, once you've preserved the evidence, tried to make sure you're not spoliating anything, then you get to the actual litigation. And when you get to the courthouse, I mean, I think all lawyers in e-discovery are familiar with the federal rules of civil procedure, the ones that pertain to e-discovery, the case law. But something that seems to get overlooked a lot is knowing the judge and specifically knowing the local rules of that jurisdiction. Are you finding that to be an issue?
That is a periodic issue. Almost every day, if not every week, motions are filed, papers are filed that don't comply with the local rules or don't comply with the judge's procedure. So the first tip or the first suggestion that I would say is if you are a lawyer and you're coming into a case in federal court, find out who's the district judge assigned to the case and find out who the magistrate judge is assigned to the case and find out their local procedure. Usually, in my circumstance, I have a discovery procedure which is published. I issue it in every case. It's on the website, the court's website, and it gives you the procedure of how to bring forward a discovery motion. Most of us have those. Magistrate judges, district judges have those procedures in place, but they're all a little bit different. And if you don't comply with what it says in that specific judge's requirements, in that judge's order, then you're going to run into problems. So I know it can be difficult sometimes for the practitioner. There's a lot of district judges. There's a lot of magistrate judges. It's not the exact same procedure for everybody. So it really is important, I think, that when you get into the case, find out who your judge is, who's going to be handling it, and what their procedure is, whether he or she requires a written motion, or, some judges have a calendar where every Friday at 3:00 they hear discovery disputes. I don't do that, for example. I require a motion to be filed, but it has to be no more than 5 pages, and the response has to be within 5 days. And before a motion can be filed, you have to engage in personal conferral. In other words, instead of just sending emails about the dispute, actually picking up the phone and trying to talk to the other lawyer to honestly resolve the dispute before you file it. So it really is important that you know your local rules in the district that you're in, because they're all a little bit different, and that you know the procedure of the judge or judges that you're in front of. Otherwise, you're gonna strike out.
Thanks, Judge. You mentioned some of the 20th century things you can do to make sure you don't run afoul of the judge. Pick up the phone, meet and confer, talk to the other side. Let's take it to the 21st century. COVID certainly threw us for a loop, and a lot of proceedings went virtual. You have had some case law on the issue. You obviously have experience with it. It's another challenge when you're coming in. What do you think about the practice of law before you and other judges in the virtual world?
Well, that's interesting. I think things have changed a lot in the last couple of years. Before COVID, we really were not doing too much in the way of remote hearings. Post-COVID, now that we have all got the technology working, and we've seen, many of us have seen that we like the procedure, and we like especially the civil hearings being held by remote procedures, mainly Zoom or other types of programs. We are using it quite a bit. I know that I do use it quite a bit. Now, for criminal cases, those are all in the courthouse in person by and large. For civil cases, obviously trials, I've had several post-pandemic jury trials, and those have been live in the courthouse, of course. But for hearings on discovery disputes, maybe hearings on summary judgment motions, hearings on all types of other matters, we are doing many of them remotely. I use Zoom quite a bit. It's not unusual for me to have many hearings each day by Zoom. And there is a way to practice when you are using Zoom. I mean, I think that lawyers have to have in their arsenal, they have to have their procedure where they handle an in-court hearing or an in-court trial, but they also have to be up to date on how to handle a remote hearing. It is different. You need to have a good internet connection. I know that sounds basic, but it's important. You need to dress appropriately. Just because you are appearing remotely doesn't mean you can lose the tie and lose the jacket and come in a t-shirt or something of that nature, which we do see all too often. It still is an in-court formal proceeding. You need to look at how you appear. What is your background? I've had some lawyers come in and they look good, they're dressed well, they have a nice background, their speaker works well, and I can hear them well. I have other lawyers who come in and they've got all kinds of boxes and junk and garbage cans behind them, and you can hardly hear them, and there's dogs barking and everything else. That's not a very effective advocate. If the client is watching, I'm not sure the client would be that happy with that type of a presentation. It's also, I think, really important, the remote etiquette, because it's much easier in remote hearings to talk over somebody else. And I try to make sure that I sort of am the head of the hearing, and I tell all the lawyers, listen, I will tell you when it's your turn to talk. Please don't interrupt another lawyer. I will give everybody a chance to speak. I will do that at the end. I'll see if there's anybody that has anything else to say, but don't interrupt. Don't speak over other lawyers. Don't interject when it's not your turn, because it does destroy the remote proceeding. And I think a lot of judges, those who don't like the remote proceedings, it's because of some of those reasons. Lawyers talking over other lawyers, not appearing properly. And another thing that I have run into several times is just not appearing on time. If you have a 3 p.m. hearing, you should be logging in at 10 minutes to 3 to make sure that you have everything under control. The old adage, on time is late and early is on time, it does apply. And there's nothing more frustrating than for a judge to have a hearing, and I do everything I can to be on time, even though I have a lot of other matters. You sign on, you log in, one side's lawyer is there and the other side's is not. And then you have to either proceed with the hearing without that lawyer or ask the other lawyer to call that lawyer's office. And it's very frustrating. So those are some of the tips and pointers that I would suggest. Remote proceedings, at least for me, are here to stay. I am going to continue using the remote proceedings. I think they're helpful for lawyers. They're helpful for me. And I think that they reduce the cost of litigation to clients. And I think they do advance Rule 1's purpose, which is the just and speedy determination of civil actions. But it is important for everybody to know how to handle civil hearings, remote hearings, and to put in your arsenal that this is part of practicing nowadays. It's not just being in the courtroom live, it's also appearing remotely, and you need to do it the right way.
Thank you, Judge. The Honorable William Matthewman, United States Magistrate Judge for the Southern District of Florida, with words of wisdom on everything from preserving the evidence, avoiding spoliation, knowing the local rules, and of course, dealing with things in the virtual world. You can see Judge Matthewman as he joins us for the annual judicial panel. It will be held next Wednesday, that is February 8th. It will be at 4:00 p.m. Eastern. Please tune in if you're not joining us locally, live in Gainesville. Judge Matthewman, thanks for spending a few moments with us today.
Well, thank you. Good seeing you again, David, and I look forward to seeing you during the conference at the University of Florida.